130.
Good afternoon, members. We've had apologies from Megan Fearon and Gordon Lyons. Are we aware of any other apologies or latecomers? Okay. Members, page 6 of your packs is a save the date notice, and this is about a review of the Victims and Survivors Strategy, which, as you know, is a 10-year strategy which started, I think, in 2009, so expires in 2019. It's scheduled for the 9th and 10th of March at Titanic Belfast, and the Commission for Victims and Survivors who are running it are indicating further information will follow. So it's not clear whether it's a sort of mid-term review, in which case it's a bit late, or whether it's advanced planning for the next one, in which case it's very timely. So we'll give them the benefit of the doubt and await further information. A list of current invitations is at page 8. We move on to draft minutes of our meeting held on the 13th of January, beginning at page 9 of your packs. And the question is, are members content to agree the draft minutes of the meeting of the 13th of January? Agreed. Thank you. As to matters arising, members, you'll recall last week it was agreed the Deputy Chair was going to bring forward a proposal regarding our consideration of the forthcoming transfer of functions order for us to think about today. The committee will receive a briefing on the proposal for the transfer of functions order from officials next week. And just before we hear from Chris, can I refer members to a piece of correspondence? It's from the Chief Exec of the Orchardville Society. And the Chief Executive is raising concerns about the proposed transfer of employment services to the Department for Communities, and that's entabled at page 11. Just on that, are members content that we ask the Committee for Employment and Learning, the Committee for Enterprise, Trade and Investment, and the Committee for Social Development for their views on the points made in the Orchardville correspondence? Yeah, thank you. And are you also content to copy the correspondence to the Department in advance of next week's briefing on the transfer of functions, in case we want to ask them? Thank you. Okay, Chris.
Thanks, Chair. My proposal is fairly straightforward. I would suggest that we publish a 2-week window call for evidence in relation to transfer of functions, and dedicate a session to consider evidence and have an opportunity to call witnesses to consider that evidence if we need to in more detail.
So over 2 weeks you would bring people in front of committee, potentially?
Give a 2-week window for people to submit written evidence, and then
decide whether we want to
a witness session then, yeah. I suppose, Chair, to elaborate on that, I think, whilst unrelated, the correspondence from the Orchardville Society is an example of the type of concerns that have been raised with me. They're not numerous, but they are of substance, and in short, Orchardville Society's concern, who does essential work with people with learning disability and accessing employment, is that the current proposal is for the employment service to rest with the Department of the Communities rather than the Department of the Economy, and the concern is that if the employment service is with the Department of the Communities, that it will be much more compliance in welfare terms driven rather than employment opportunity and skill driven. Given, I know we've written to other committees to seek their views, but I'm not sure how proactive they've been in seeking external stakeholder views, and how substantive the responses that we're receiving from the committees are, versus us taking a role to try and engage with stakeholders and just give them an opportunity to submit some written evidence for our consideration when we're forming our response to the transfer of functions, given that it is in the unique situation where this is the only real window to make submissions and seek to persuade First and Deputy First Minister of arranging it in a different way. Once it gets to the Assembly, it is an affirmative resolution and it's a yes or no, not a can we amend this.
Yeah, that's true. And I'm certainly aware, Chris, of stakeholders who are pointing out what they see as inconsistencies, perhaps, such as the one you highlighted. I suppose the potential danger is you get people who want to argue about whether we have the right functions rather than that the functions sit in the right departments, and this is not about opening up how we do government to new policies, no matter how worthy they may be. My other concern, just reacting off the top of my head, Chris, is many stakeholders. How do we access a relevant stakeholder database? Because we're doing the entire gamut of government, aren't we?
I can understand the point Chris is making, but I just think it's a bit foolhardy, because the department at the stage of the game, you would just saying, if you open that up, that discussion for no matter how many, you're going to cut departments down from X 12 or whatever to 9. You're going to be submerging some groups within other departments or merging them into other departments, and you could cut that 100 different ways to still not get a full agreement. I just don't think that we could do such a stakeholder engagement justice, and I think there'll be a lot more people who will end up thinking they're excluded from the discussion than included. I just don't think it's going to take us any with this stage. Cause more noise.
Anyone else?
You could end up duplicating other work that other committees may well do. I know OFMDFM would have a unique place in all of that, this committee then also, but I just would worry that you could have a committee this week or last week deciding they'll have a roundtable discussion with a group of stakeholders that they maybe would be communicating with over the term. So I would worry about duplication. There's absolutely no problem with the logic of it and trying to consult in itself, but just how you do it.
I mean, of course, I'm very sympathetic to Chris making the point that there are people out there who are saying this isn't right, you're not doing this right, and to ignore it is not good. Just what I'm wondering, Paul, is this is a huge restructuring. I mean, restructuring happens all the time, and it's natural and it's right. This is so big. Are they going to say, that's it, and we're in a solid state for the foreseeable future? Or are they going to be open to the fact of saying, well, look, this is our best guess at this huge restructuring, but we know we'll not get it right, we know there will be improvements, and we're open to making those adjustments continuously from day one?
I think it would be foolhardy for any government or any department to say this is set in stone. If we encounter problems a year down the line or 2 years down the line, something is obvious that needs to be changed or switched over to departments, I think anybody and everybody should be happy enough to actually try and resolve it. So, I just don't know how OFMDFM committee do we just tackle the department that was OFMDFM and all the people who have moved and the people who have come in, or the responsibilities that have moved and come in. You could maybe see a level of success there, but to actually open it up into the wider.
I mean, could we write the department and ask the department had these concerns from this particular organisation or organisations that Chris was referring to addressed? I mean, sure, we all know there's been a range of organisations who have gone to the departments and asked, lobbied to have their interests represented in a different department, for example, entirely different department. So,
Yeah.
well, so you might want to do that. If maybe refer to the department, have they been asked by this particular group to consider?
Yeah, I don't think we need to write, Alex, because they're here next week.
Okay.
So,
I'm just worried about opening up an engagement. People think you're bringing them in to have a discussion with any realistic notion of getting big change. A lot more organisations think they've been left out, in my view, so I'm just a bit worried about that element, if you know what I mean. And I think Paul's point there, I mean, I think any government or any administration has to be good enough. If something's not right, we'll have to rectify it.
I'd like to hear that
Easier done,
from officials.
Yeah, absolutely, I agree with you there, yeah.
I mean, if the 9 departments are wrong, that would not be an easy fix short term. I mean, a function, you would like to think, yeah. But Chris, sorry.
Yeah, Chair, no, appreciate the comments. I mean, one way to target it in is for a call for evidence in any session to be just with key components relating to OFMDFM, so commissions, for example, Children and Young Persons Commission, and perhaps take heart from the fact that we are forwarding Orchardville Society correspondence on to committees. Maybe we could just check that committees are, proactively seeking concerns from bodies that relate to their particular department portfolio then.
Sorry, Paul, go ahead.
Sorry, you could actually add to that. You could actually say, well, we only write to the ones that we have directly consulted with on the OFMDFM committee. But you could ask them the question, do you see anywhere else in government that there could be a direct or indirect consequence, a negative consequence to the work that you do? Because obviously we're not in silos. Yeah. We don't live in silos or operate in silos. So that could be a way of opening it up to the people who we are targeting.
Can I make a proposal, Chris, that we will be obviously compiling a legacy report to leave for the next committee, which will be the committee of the Executive Office. We could make a recommendation that they keep eyes and ears open to assess the efficacy of the new functions and how they are performing under the new 9-department model, and if they're hearing enough negative noise that they hold a hearing or do something.
Yeah, that sounds like a good proposal, Chair. I think it might at the least be interesting to in advance also contact some of the key components that relate to OFMDFM, the commissions, for example. I know people are keen to make sure there are justifiable lines drawn so that people don't feel like they haven't been approached, and that we don't cast nets too wide either. I know that Children and Young Persons Commissioner does have a concern with proposals relating to where that function is going, and I suppose if we can at the very least make sure that we make representations in that regard, and I think check with committees that they are being proactive about this issue, given that this is the only real way for anyone to try and influence the outcome of the transfer of functions order, which a lot of us stressed when agreeing to accelerated passage for the department's bill itself, being the most important aspect of the restructuring.
Okay, so we have asked the committees.
We have, sure, yeah.
So that's done.
Okay.
You want us to write to all the relevant arm's lengths, or just to Nikki?
I think it might be useful writing to the arm's lengths, yeah.
Anyone against? Okay. And then the third thing is, we'll find a form of words for your approval, a draft for the legacy report recommending the next committee at least keep their eyes open and are aware in case there are issues arising. Okay, thank you, members.
Sorry, just supplementary matter. Could we get a paper from OFMDFM about the number of staff that will follow the transfer of each functions in the FM and DFM to elsewhere in the new structure?
56.
But who follows who? So
who's going where?
Yeah, what's the staff complement that will follow to communities on the far side of, say, the older person's function being transferred? I was a wee bit surprised picking up how limited staff complement might be that's transferring from one to the other department.
I'm sure they said 56 last week.
In total,
yeah.
What is the specific
what's the breakdown
in respect of each?
Okay. All happy enough? Content? Okay. Outstanding correspondence is next, members. It's page 20. In the absence of comment, there's only been one item received since we last met. That's from the Committee for Finance and Personnel. They've contacted us regarding the Peace 4 programme. It's in your pack beginning at page 21. I'll pause briefly for potential comment. In the absence of which, we move on to the draft forward work programme. Page 134 of your pack, you'll find correspondence from the Departmental Assembly Liaison Officer, which proposes that the committee receives written briefings on the sexual orientation strategy and the gender equality strategy in the first instance, and then oral briefings could be arranged when these strategies are sufficiently developed. I think it would be unlikely that oral briefings would be scheduled before the end of the mandate, members. Any comments, or are we content?
Content with the process, but yeah, these are strategies well overdue. I'm sure there's much we can do to expedite those at this stage, but that language suggests we shouldn't expect to see those strategies this mandate. Am I wrong?
No, I don't think you're wrong, and I don't think they'll stay with son of OFMDFM committee. Will they're transferring?
They're going to communities, I think, both of them. Yeah.
Do we get any confirmation if a paper is being tabled at the executive meeting tomorrow in respect of historical institutional abuse matters?
No, I think we all noted the words of Junior Minister Pangolin, who I think at one point in question time gave me the very clear impression that the options paper had been distributed to executive ministers, but then went on to be slightly less clear as to whether they had or were in the process of being. So that's where we are.
Well, let's assume that it has. What happens then in terms of communication with the committee?
Well, we should be in receipt of them as well, because the letter was very clear once they had been distributed, once they were in receipt, not after they've made a decision. So I think we are seeking clarification.
Sure, yes.
On foot of the remarks in the chamber from the OFMDFM Junior Minister. So members, the draft forward work programme is at page 135. You may wish to note FM and DFM are scheduled to appear on the 10th of February. And as mentioned earlier, we will receive a briefing on the transfer of functions orders next week, which is when we had originally hoped, but had never been confirmed, that the First Minister and Deputy First Minister would be with us. So it will be next month on the 10th of Feb. So, given all that, are members content with the proposed forward work programme? Thank you. Today we hear from departmental officials on the outcome of the consultation on age discrimination. A number of papers for your benefit, members. There's a clerk's brief at page 158 of your pack. Appendix 1, the written statement dated the 19th of February 2015, is at page 141. Appendix 2, which is the written statement published in the launch of the consultation and dated the 3rd of July of last year, is at page 143. Appendix 3, which is the consultation paper itself, is on page 145 and thereafter. And then in table papers, there's a briefing from the department received on Monday. It's at page 13. A copy of Nikki's response to the consultation is at 40 entabled, and finally entabled at page 48 is a paper from HNI. I tell a lie, there's also a page 50 transcripts of evidence sessions referred to in the clerk's brief, and again that is in tabled. So we are joined by Jenny Laverick, Bevan De Breen, and by Margaret Rose McNaughton. And members, Margaret Rose has pointed out her hearing is not in great shape today, so if we can please speak clearly and directly to Margaret Rose, that would be appreciated.
Thank you very much. Thank you very much, Chair, for giving us the opportunity to brief the committee on the analysis of the responses to our consultation. You have a copy of the briefing paper, and we'd be happy to talk members through that paper if that would be useful. I maybe begin with the background to the proposals and the consultation process itself. Members will recall that Junior Ministers McCann and Bell in April 2015 briefed the committee prior to the consultation. The proposals for legislation in this area would address the gap in our current suite of anti-discrimination legislation where there's currently no protection in relation to age discrimination outside the workplace. The main elements of the proposals for legislation are outlined in the executive summary, which we've included in the briefing papers. In short, the proposals are to protect adults and young people aged 16 and over from discrimination on the basis of age in relation to goods, facilities and services, charities, premises, education, public functions and private clubs and associations. Our consultation proposed a number of areas where we considered that different treatment of people of different ages would be justified and where exceptions to any future ban on age discrimination would be necessary to allow certain age differentiated practices to continue. We also set out proposals to give people who feel that they have been discriminated against the right to challenge that treatment in court and to give the Equality Commission for Northern Ireland certain functions and powers in relation to any future age discrimination legislation. We'll describe in more detail the nature of the proposals as we go through the public response to individual proposals, but for now I'll just briefly describe the approach we took to consultation. It was launched on the 3rd of July and ran until the 8th of October. It was a 14-week period and it was longer than usual because obviously it was over the summer months. The consultation document, executive summary, young person friendly version were all published on our website and were available on request. We designed a consultation questionnaire to help people to respond to the proposals. It was launched by press release and the consultation documents were issued by email and hard copy to around 1,900 individuals and groups. So we were trying to reach as wide a range of people as possible. That included statutory, private, voluntary, community and religious organisations. And the groups were actually asked to circulate the information to their members to ensure the consultation was circulated as widely as possible. And we also held a number of events around the 6 counties and in Belfast. Information about these events was circulated to our full consultation list and advertised in the local press in each of the counties and in Belfast. At each event, the participants were given an opportunity to discuss the proposals, the general exceptions, the financial services and other proposed exceptions. We took a record of all of those views and that they are included in our analysis of our responses. With your agreement, Chair, and you may decide which way you want to handle this, but Bevan and Jenny are here to talk us through the remainder of the paper and to answer questions, maybe as we go along, if that would be helpful. Okay, so I'll ask Bevan then too.
Yes, so as we said, the consultation finished in October and there were 222 formal responses in total, and they were in sort of 3 separate formats. There was 77 people chose to use the standard questionnaire that we had designed and answered in a structured way. 96 responses were from the Northern Ireland Youth Forum, and they were partial responses which focused largely on the question of scope and the age and also on the equality impact assessment. And in addition, we got 49 written responses, largely from organisations and advocacy groups, and these were substantial and lengthy reports in many cases. We've looked at the range of responses across the questions posed and the range of proposals that we put forward, and some of the issues raised are fundamental to what's being put forward and some are more technical and more subtle, and we've tried to analyse in quantitative and qualitative terms what people have put back to us and where applicable the nature of the concerns and the strength of opposition to individual proposals. As I said, some people chose to focus on a limited number of questions, whereas other people addressed their concerns more broadly. And ministers will have to consider the range of views put forward in determining the final policy position, and we're committed through our consultation document and our equality scheme to publishing a full report on the consultation along with the final policy position in due course. There were some key aspects of the proposals where there was strong opposition, as I've indicated, and we'll look at those in more detail, but first I just want to cover the broad areas of consensus. In principle, most people welcomed the consultation, and the majority of the proposals were accepted by a majority of those who responded. So many of the elements were uncontroversial and were welcomed. Most respondents agreed that the legislation should apply to goods, facilities and services, public functions, private clubs and associations, charities and premises. And a majority agreed with the proposed definitions of direct discrimination and indirect discrimination, harassment, victimisation and other discriminatory behaviours, which are in line with other anti-discrimination legislation. Most respondents also agreed with the proposed objective justification test and the positive action being proposed and the general exceptions, although a small number were concerned that the exceptions proposed for immigration and care within the family were too broad, so we need to bear that in mind. A vast majority of respondents agreed with the proposal to include health and social care without exception, and that was seen as a very positive inclusion and was warmly welcomed across the board. There was qualified support for age-based concessions that's dealt with in more detail in paragraph 39 to 44 of the briefing paper. A number of respondents also then requested clarification in relation to some areas and suggested areas where the legislation and or the accompanying codes of practice would need to ensure clarity and define things for people. So then the question of age was the one question where it generated the largest volume of responses and the largest proportion of those choosing to respond. And there were strong concerns expressed about the exclusion of under-16s and also about the lack of a satisfactory rationale for that position. And some respondents also have questioned the genuineness of the consultation exercise and whether or not the issue of scope has effectively already been decided. So those concerns have been put to it. A majority of the written responses were in disagreement with the proposal to exclude those under 16. And again, the written responses largely came from umbrella organisations and advocacy groups. So that's that's generally those who chose to write to us in a free-form report style. From the Northern Ireland Youth Forum, 90% of those were also in disagreement. When it came to the questionnaire, this would have largely been individuals rather than organisations, and in that case, 60% of people were broadly in agreement with the scope as proposed, although there were 30% either disagreed or strongly disagreed, and where those who disagreed put similar concerns to those we heard through the written submissions and through open-ended responses. Some of those who responded did acknowledge that the proposal to extend legislation to those 16 and over was progressive and a step in the right direction, as it would provide greater protection than currently exists in Great Britain or Ireland. Many of those who came to the consultation events also felt that all ages should be included in principle, but there was strong feeling that legislation needs to be introduced as soon as possible to give protection to older people, and the position that children and young people could be protected at a later stage. So that view came out more from the consultation events than from the formal written responses. And a small minority thought that legislation should apply only to those 18 or over, but that was very much the minority. Jenny has more detail on the questions, the responses specific to education and financial services, if you'd like to.
Yeah. Certainly. Jenny, do you mind just one second while it's still fresh in my mind? You said that 60% of individuals who responded who were content that it was only 16s and overs. Yeah. Do you have the age profile of those individuals?
I don't have that to mind, no, but it was individuals rather than not everybody. See, not everybody will specify that. I don't think that emerged as a definitive statistic. But I can.
Useful. But yeah, okay, that's useful to know. Okay. Benny.
Certainly, as Bevan said, I'm going to highlight some of the key issues arising from the consultation responses in relation to financial services, education, and the equality impact assessment. So, in relation to financial services, first, you can find this at paragraphs 30 to 38 of your briefing packs. The consultation document proposed a specific exception to allow financial service providers to continue to use a person's age as a criterion in designing financial services products. That is identical to the exception currently in place in Great Britain. Financial services is regulated on a UK-wide basis, and as a reserved matter, any provision for financial services in legislation would require the consent of the Secretary of State. Our consultation document also included the adoption of 2 voluntary schemes with the insurance industry. Again, these are currently in place in Great Britain, and they're designed to improve access and transparency, particularly in relation to motor and travel insurance. For the most part, these schemes actually already operate here in practice. Overall, respondents were opposed to the proposed exception. Most were opposed to any exception at all and thought that any age-based differences in treatment should be objectively justified. Others thought that the proposed exception was too broad. For example, they thought that age should only be used as a factor in deciding product or prices where it is proportionate to the risk. Some other respondents suggested including a commitment to review the impact of any exception included in the legislation. This area attracted a significant number of responses and a lot of discussion at the consultation events. Many people raised personal examples of age-based treatment that they considered to be discriminatory, other barriers to older people, in particular from accessing financial services, as well as a general lack of confidence and trust in the financial services sector. We received one consultation response from a body representing the interests of the insurance industry. This respondent strongly supported the proposed exception for similar reasons to those put forward in the consultation document itself. A number of respondents in all formats expressed concerns around how the voluntary schemes are working in practice in Great Britain and how those schemes are enforced. Other respondents expressed a preference for those schemes to have a statutory footing to make them stronger. A review of those voluntary schemes is ongoing, is being led by Treasury, and the outcome of that review, if available, is something we would wish to consider when finalising our policy proposals in this area. So in relation to education then, at paragraphs 45 to 48 of the briefing, the consultation document did not set out any specific proposals in relation to education. Instead, we asked people to consider whether there were any issues which could result in unintended consequences in the education sector, and whether any specific exception would be required to ensure that certain age-based practices would be allowed to continue. Respondents who commented on this issue generally thought that education should be included within the scope of the legislation, and that this should also encompass the Education Authority and the Council for Catholic Maintained Schools, who have various public functions under the education orders. Some respondents highlighted issues which would need to be considered in more detail, such as transition processes for young people with special educational needs, and 16 to 18-year-olds attending link courses in other colleges or other educational facilities. Other respondents raised issues that fell without the scope of the education in relation to lifelong learning and barriers to older people in education. But when we were talking about education in this context, it's specific to schools. Age-based policies and practices are widespread within education in schools, for example in relation to admissions. We need to be very careful to ensure that the inclusion of education within the scope of any legislation would not result in those unintended consequences. For example, that the legislation would prohibit a type of age-based treatment that is actually considered beneficial. It is likely that many of the policies and practices that would already be permitted under the proposed statutory authority exception or objective justification, but we do need to be sure before finalising our policy proposals in this area. We are continuing to work with the Department of Education and other stakeholders to assess the impact, and this work will be informed by the responses we received to the consultation. In relation to the Equality Impact Assessment, at paragraphs 49 to 53, many respondents welcomed the publication of a draft EQIA, but a significant number raised concerns in relation to the evidence presented, the assessment of impact on particular groups, particularly those with multiple identities, and the identification of mitigation measures. Many responses used this opportunity to reiterate comments that they had already provided on the scope of the legislation in relation to age. Some respondents also expressed concern that the policy proposals were not evidence-based and that there is unwillingness to take whatever measures necessary to mitigate against the adverse impact identified on those aged under 16, or to bring forward an alternative policy. Many people were concerned that the young person-friendly version of the consultation document did not include a question on the EQIA, and that there was no direct consultation with children and young people on the EQIA. A number of respondents also provided additional evidence and analysis of the impact on particular groups. Others sought more specific mitigation measures, consideration of alternative policies, and details on the monitoring arrangements. Work is continuing on the EQIA in parallel with the policy development process. All options put forward for consideration will also need to include assessment of the impact of that option, and that will take account of the comments and additional evidence provided by respondents as part of the normal policy development process.
Okay, thank you all very much indeed. I suppose the first question, Margaret Rose, is to what extent does this tell you that the public will is to extend this legislation to under 16s?
Well, I think clearly, I mean, the vast majority of responses have suggested that they would like to see under 16s included in that. That is something that we need to be putting forward then, of course, as an option. While the original intention in the consultation document was that this would apply to over 16s, I think junior ministers made it clear as well last April that, I mean, this was going to be open consultation and that they wanted to hear the views of the public on the issues.
So the public will is for extending it to under 16s?
Well, clearly, for those people who responded to the consultation, clearly they are suggesting that they would like to see this apply to under 16s as well, yes.
And the Commissioner for Children and Younger People has made clear, I think, that if you're going to stick to the gunning principles in consultation, if you're going to be true to saying that the product of consultation must be conscientiously taken into account, that you will include under 16s.
Well, I mean, that won't be a decision for us. Obviously, we would be putting forward what people have said during consultation, and I mean, obviously ministers will want to deliberate on all of the issues raised during consultation, and that will be a decision that they will need to take.
So to take on board or to prudently ignore?
Well, no, I mean, they will want to consider all of the comments that were received during consultation, and the documents that we put forward to them will include all of that information.
I'm interested in financial services. How difficult an area is this to legislate for, given it is not a devolved matter?
Well, I think in our case it'll be extremely difficult. We had, I think, one respondent from the financial services organisation itself. Basically, they do not want to see us going any further than what they have been doing in GB and indeed in Ireland as well. And when we get to the EU Equal Treatment Directive, you'll see the way the EU has been handling that as well. I think there is always that fear that if insurers, in particular insurance companies, aren't allowed to take age into account, that additional costs of that would have to be borne then by the general pool of those people who pay for their insurance, which may result in higher overall costs. So I think it might be very difficult for us to put forward anything different.
But I think that the broad principle is that there's an acceptance that proportionate differentials can be applied. That takes you into areas of subjectivity and judgment calls, which presumably are tricky, to say the least.
Absolutely.
Well, I think the question of proportionality it would go further even than the position that's in place already. Is that fair to say? Yes.
Yes, that's correct.
At the moment, there isn't even a requirement that the differentials be proportionate. It's that you can take age as a factor in a risk assessment, as long as the assessment, as long as you're using evidence that's reasonable to rely on and from a reliable source. But how you then make your differential, there is not currently a requirement that be proportionate. That's something that's from the language of the EU Equal Treatment Directive, but that currently goes further than the position at the UK level.
And is there a danger, because we've mentioned the Equal Treatment Directive coming out of Europe, is there a danger you will legislate for something that you'll then have to amend?
I think the timing on the EU directive will be made, there's a risk assessment on that. The timing is not immediate, fair to say.
Well, I think that's right.
For yours or for theirs?
For theirs.
Oh.
For theirs.
Okay. Unintended consequences in education, what might they be?
Well, that's what we're trying to identify. A lot of people have raised concerns with us, as we say, that may well come under other statutory provisions and would therefore, under our current proposals, be permitted. I think it's in and around other questions, things like, down as basic as sort of school trips, allowing 1 year to go on a school trip and not opening up to another one. It's just making sure that we don't stop something that's fair enough from happening, but that work with the Department of Education and other stakeholders is ongoing to identify that. We certainly know that some people raised some of those issues. Most people thought that there probably weren't any unintended consequences in education.
But
Maybe.
we've all been to school. We've all worked or studied with people who are way ahead of their age group, perhaps in a certain subject. People who are fantastic at languages. So could you not, potential of a year 11 student taking some sort of case because they're not being allowed to sit their A levels with the year 14s.
That is a
If those are the sort of issues that we're looking at.
Or even a case that was raised as in discussion with education colleagues that significantly older people insist that they should be allowed to go to a secondary school with younger pupils. So they're looking at a range of issues. They need to carry out their own audit of practices to kind of just challenge.
And for the avoidance of doubt, I'm not saying a year 11 should not be allowed.
Indeed, yeah. No.
But it does have significant implications for how you manage a school.
Yes.
And I do think the admissions and the age limits for admissions is one of the concerns that certainly the Education Authority and Department of Education would have. And that's what we want to look at as well a little more closely. So
somebody in P5 may argue, I'm ready to go to big school.
If they were covered within the scope of the legislation. Yes.
Okay. The EQIA was not in the young person friendly consultation.
There wasn't a question on the EKIA included in the young person's version.
Because
the young person's version was very succinct, obviously, and was attempting to cover a large range of them. It wasn't a deliberate decision to exclude it, it just wasn't included in it.
It was developed on our behalf by the participation network as well, people who can defer to their expertise and
do you not think it should have been?
Digest.
I think probably in hindsight, yes, it probably would have been useful to have had one of those with a question in it.
I'm sure concise is good, but so is comprehensive. Alex Maskey.
Thank you, Chair. Thank you for the presentation. We're here again. So I think obviously we're all faced again with the kind of dilemmas that we all, presumably around the table and in the room, want to make sure that everybody's protected against any form of discrimination. And certainly the older persons advocates have been very solid and very passionate about trying to get something within this mandate to protect our rights going forward, and that's what we've been trying to achieve. On the other hand, we have younger persons advocates who are equally passionate and determined to defend the rights of that sector not to be excluded from the action that would be warranted for the older persons. So I think the problem we had, and we've addressed it here before, of course, that some of us had the difficulty that we couldn't get agreement to have everyone included in it, and that's just the political reality of it. That's something that my party was happy with. Was that compromise proposal of going from 16 years of age up? I think yourself, Bevan, has said it was seen by most of the respondents as progressive. But the consultation has, I think, thrown up, into stark relief that the contradiction within all of that. And for me, I think it does then pose a really big difficulty for us, because on the one hand you do want to deliver on the commitment to older persons, but at the end of the day, if that's going to be at the expense of, and I wanted to ask a specific question on this, a challenge, because I understand from some of the stakeholders that I've spoken to that they've actually served notice on the department that they'll take legal action if younger persons are excluded from legislation. So, I mean, for me, that's a very significant Damocles holding over us on this one, because if you're going forward on the basis that there's no rationale, and I don't understand the rationale for excluding people under 16, I just know some people have their own justification for that. So my dilemma would be, how could I possibly go forward on the basis that while I want to put the legislation in place, equally I'm not going to put my head on the noose for, what's quite clear and black and white in front of us, and you're giving us evidence today that the consultation has produced the results that certainly I was always convinced it would do. So can you give us a bit of light on the stakeholders who have said that they will take action in the first instance, and what the qualitative response may be on that?
Well, in terms of, we've had initially a pre-action complaint letter from the Children's Commissioner, which is now actually a formal
We
complaint.
refer to the Equality Commission.
Has been referred to the Equality Commission as a formal complaint, and indeed we have a pre-action complaint letter as well from the Children's Law Centre, which is still being dealt with. I mean, clearly the final policy position hasn't been agreed yet, so those issues will form part of the documentation that goes forward, you know, and will need to be taken into consideration as part of the deliberations on how we finalise the policy proposals.
I appreciate that, and in terms of some of the work that you said that was ongoing, I welcome very much the fact that there is work going on with a range of departments and so on around what may be I think you mentioned the unintended consequences. I think that obviously would be important. I mean, some of that I think, not from anybody around this table, but sometimes I think some of that is a bit of a fear or a scare, nearly almost. I mean, we all know that, you know, a 16-year-old or 14-year-old might want to smoke and might smoke. Nobody's going to sell them, and nobody's going to advocate selling them cigarettes. If you know, even though an adult can buy cigarettes, so there's, you know, to me there's a common sense kind of rule applied here as well. But I do appreciate that there may well be issues thrown up. Someone might say, well, if they're entitled to do it, so am I. So I just do welcome the fact that that work's going on. But is there any sense of any of those issues, are there any big ticket issues in there which have been discussed in any way, in a substantive way, or is there just a range of issues been thrown at you as potential reasons why you couldn't include young people, for example? Well, I know the kind of, sorry Margaret, but the kind of key what I'm trying to get at here is, I mean, obviously there's a lot to be thought through there in terms of the consultation response. People do rightly expect an early answer to all of this. So is there much work which is underway in that at the minute which would take any undue length of time?
Well, in terms of time, I mean, it's difficult to say how long it will take for that. I mean, the last meeting that we had with the Department of Education and the Education Authority threw up some issues around, you know, where they have school rules, you know, for maybe fifth years, and you know, in a fifth year you could have a 16-year-old, and then in lower sixth you can have a 16-year-old, and there may be differences there. And you know, would you be discriminating against the person in fifth year or the person in lower sixth? So there's issues around that people want a little bit more time to think through, and certainly the Department of Education are doing that for us at the moment. We will want to, I mean, and again, it is a timing issue, and just trying to get all the process right as well as we go through this. It's just trying to get the time now to go back to education and see what other issues they have identified. Certainly, the admissions and the children then of the same age in different classes were two issues that were thrown up to me. Other people, I suppose, hadn't, certainly during the consultation events, people hadn't really thought that much about it beforehand, before we presented it to them. And in the responses that came back, the written responses, there was little detail really in terms of, you know, what people thought might be the implications. So you know, you're right. It may be that there are not that many unintended consequences, or that, you know, that may be more fear than anything else. But I think we just want to try and satisfy ourselves that we have done all we can do to identify those.
Thank you.
Margaret Rose, how often do you get these pre-action letters with regard to consultations?
Well, that's the first one I have received.
First two?
For what, sorry?
First two.
First,
Yeah.
oh, sorry, first two. First two.
What can you tell us about the nature of the complaints?
It's about a breach of the equality scheme, that the way in which the consultation was held went against our own equality scheme in terms of how the policy proposals were developed, and also how the information was presented, the lack of a rationale, that would be part of the, there's also an assumption that, or a sense that the outcome is effectively predetermined. So that's part of the, that is the nature of the challenge, is about how our compliance with the equality scheme.
There's also a little bit about the length of consultation time for young people. because the young person's version was not available at the time that the consultation itself was published. It was available within 4 weeks after that. So there is part of that is about direct consultation with children and young people as well.
So the nature of the challenge tallies with the nature of the concerns raised by a number of respondents through the consultation. It's, if you like, it's a formalisation of the concerns that were expressed through the consultation. It's not additional to what we heard and what we've been considering through the consultation.
Leaving aside the Children's Law Centre and focusing on Nikki, the Commissioner for Children and Young People, that's an arm's length body of yours. You're not embarrassed that you couldn't bring them along with you, keep them informed, make sure they approved of what you were doing? Are they not there with a statutory duty to advise you?
Well, indeed, we do take very seriously what the Children's Commissioner say, but if I could refer back to, last April when the junior ministers were here and were explaining, in one case, disappointment at, going forward just with under 16s, and in another where, I think it was Junior Minister Bell was explaining that this was a first step in a direction of bringing forward age discrimination legislation, which is a big gap, obviously, in our equality legislation. I think people recognised that there was going to be disappointment, and why we obviously did try to bring people along. It was an opportunity, at least, to get out to consultation, to test the views, not just test the views of the public, but actually, test the areas where people had been suggesting that under 16s be included.
The Commissioner has half a dozen statutory duties, one of which is to advise you. And they did advise you.
Yes,
And you didn't take their advice.
Well, again, this was it was a political decision that was taken ultimately that you go with the over 16s.
Let me clarify when I say you, the department, OFM, did not take the advice, and now we have the prospect, at least, in these austere times, of spending taxpayers' money on a legal case that I think reasonable people think should have been headed off at the pass by ensuring everybody was content before you pressed the button on the consultation.
Well, I suppose it's difficult to be sure that everybody's going to be content initially. And
okay, maybe not everybody, but at least an arm's length.
I appreciate that.
With a statutory duty to advise you, the department.
They have indeed, and we did try. We had a pre-consultation with the Children's Commissioner and with the Equality Commission and
the Older Persons
Commissioner. We did try to explain to them, what it was we were trying to do, and while people were, they were pleased that at least we were trying to do something, and pleased that we were going slightly further than indeed in GB, because the 16 and 17-year-olds were going to be included. There was still the concern that the under 16s weren't going to be included, but at least we were going forward with something.
I'm not going to linger on it, Margaret Rose. This will be my last comment, and you can reply if you wish. But your language is interesting. You brought these people together to try to explain to them what you're trying to do. Not we brought them together to say, here's the objective. How do you think we should try and achieve it?
Well, probably an unfortunate choice of language on my behalf, but we did actually sit down with those bodies, and we did attempt to get some kind of just agreement, certainly in principle, as to how we would go forward with the legislation on the basis of, this at this stage is going to be for children, or for people over the age of 60.
Deputy Chair Chris Little.
Thanks, Chair. Thank you for your presentation. To follow up on the Chair's questions, in case I've missed a bit more detail, what was the reason for not including the draft EQIA in the young person friendly consultation?
There was no reason for it. We, in developing the young person's version, we asked the Participation Network to do that. They're the experts in it, and sent the consultation document to it. So maybe some fault on our behalf for not thinking about that in retrospect, but it wasn't a deliberate decision. Okay,
so there wasn't a particular official or minister who took a decision not to include the EQIA? Okay, and do you believe that was a mistake that constitutes a breach of the Department's Equality Scheme commitment?
That's certainly what some of the responses to our consultation and the pre-action letters have told us. That's something we will look at.
And in what way do you tend to respond to that? What's the time scale for response, and what's your intention of how to respond?
In relation to the complaint?
Yeah.
The complaint submitted by the Children's Commissioner has gone to the Equality Commission to investigate under the Northern Ireland Act, and they'll choose to investigate that or not as they see fit.
Okay. Is there an obvious remedy to the
I don't think
issue?
that's something we've considered yet, and subject to the outcome of that.
And will that potentially delay delivery of the legislation?
No, it's a separate process.
It is.
Yeah.
Okay. Obviously there are a few serious issues there, and there are some policy issues in relation to financial services and education that have been raised. But notwithstanding those serious issues, I welcome the time period taken for the consultation and the healthy number of responses that have been received. My party, Alliance Party, has strongly supported the delivery of this legislation regardless of age, so I was prepared to defend that position today, but you've been quite open and honest in terms of reflecting the weight of the consultation responses being strongly in support of extending the legislation regardless of ages, and I thank you for that. I've found your evidence helpful in that regard. Notwithstanding the issues then, what is the timescale, the action plan now in terms of responding to the consultation responses by way of delivery of legislation?
Okay, well, it's, when ministers announced the consultation, they did say that they would want to have an agreed policy position first and then consider the options for legislation. What we want to do now, and subject to any comments that the committee may want to make on the legislation, or sorry, on the consultation document, we will continue the deliberations, I guess, on the options that people have put forward, for taking forward. On the options for taking forward just legislation in this area. There'll be a number of options that we will put to ministers, and that will need to be then considered in light of the weight of the comments and the views that were expressed. And this is going to be, a few weeks, we will have the final documents ready for full deliberation. Ministers have been kept informed as we have gone through the process, just of the type of comments, the nature of the comments coming in. So in terms of a time frame, I would expect the final deliberations to be within the coming weeks, certainly.
In time to deliver the legislation in this mandate?
Well, I don't know that and I would doubt that would be a possibility. I think the first step is the agreed policy position, and then it would be, the will of the Assembly, or would be the committee to also support any legislation being brought forward in this mandate, because the only way possibly that could be done would be, as you know, through accelerated passage. And that's not within the gift of ministers, that's if it's the will of the Assembly.
Okay. I'm aware of the significant number of people and organisations who were strongly hoping that the commitment to deliver this legislation during a mandate that was scheduled to end in 2015 would be achieved. And I imagine from what is being said today, there'll be a significant amount of potential disappointment and concern, as far as I can see, unless it's my understanding from open debate and questions in the floor of the Assembly, I don't think I'm speaking out of turn, that the DUP hold a position not to extend the legislation to all ages, whilst I think there's a significant number of other parties who support the extension to all ages. So unless that can be addressed fairly rapidly, it seems difficult that accelerated passage is going to be appropriate, and even with accelerated passage, to actually deliver the legislation at this stage. I mean, how disappointing is it to the department that that commitment might be breached?
Well, I think we have, and we would have been very keen to have done all we can, and we have been trying to do all we can to move this forward. I mean, I think we've come a long way in the last number of months, in terms of having a consultation document developed and consulted on, and a fairly robust analysis almost completed now. So, I mean, I just, all I can say is we have done as much as we can just to keep moving it forward.
Final question, Chair. Are you optimistic, confident that the ministers will accept the weight of the consultation response, that it should extend to all ages?
Well, I can only put it forward, and it's for ministers to deliberate on then.
Okay. Thank you, Chair. Thank you.
Thank you.
Chris Hazard.
Thanks, Chair, and thanks for that. It's quite thought-provoking there today. And I want to touch upon education. Apologies, I had to pop out, and I know the Chair had touched upon education just to return, so if there's any duplication. But is there any idea likely when we're going to maybe hear back from education on so? I know they're working through some of the consequences it may. Do we know when you might hear?
Well, I mean, I think it's really for us now to go back to education again. We can do that, and I mean, that's just part of our programme over the coming weeks, just to finalise these.
Have they flagged up on again, the Chair had mentioned transitionary, even sitting here at the top of my head, you can think school starting age, sex education, these are issues that may present challenges. Have the department themselves actually flagged up any particular?
Well, again, those issues are very different depending on what scope of age coverage you're talking about. So there's a range of possibilities, and there are theoretical possibilities obviously at this stage, but just as options would be, that's again as alternatives to what are in the consultation document, may be considered, and then alongside that it expands the range of issues that would need to be looked at. So some of that, it's some of it that are hypothetical at this stage, but yeah, I mean, and it's to differentiate between things that are already covered by statute, which would automatically be excluded. For example, school starting age is something that's in the legislation now, so it wouldn't be it wouldn't be within the scope of this. But it's to try and get beyond, there's to explore the range of issues that are being identified, and then
as well as the statutory authority exception, which would allow any age-based treatment that's already provided for in legislation, or in the future would be provided for in legislation. If education was included within the scope, any age-based treatment might also be covered under the objective justification test, which essentially means that if the age-based treatment is a proportionate means of achieving a legitimate aim, and essentially because we sort of need a wider test rather than legislating for every possible scenario. Okay. So things like sex education may well fall into, you may well be able to argue that. So it's sort of looking at that, whether there's anything that wouldn't perhaps meet that test, as well as something under another statutory provision.
Okay, no problem. Thanks, Chair.
Thank you. Alex Edward.
Just a comment and a question in respect of the pre-action letters that you've received. My own view is that because of the failures of government departments, you're going to have, and rightly so, and I think it'll be healthy, more and more people going to the courts in order to challenge the failure of public policy or failure to change public policy. You see that in respect of OFMDFM around the anti-poverty strategy, now potentially around age discrimination. We saw the VSS, the Victims Commissioner, formally alert in October 2014 the OFMDFM about their concerns about what the VSS was, and you can see it in other government departments as well. And I think there is properly the citizen and communities and organisations are now reverting to the court because of the failure of the government to do what it's meant to be doing. And I think there may be a variation on that. Now, any legal advice that you've got or your ministers have got is privileged, but if you get legal advice that actually there has been a breach of process, and Jennifer seemed to indicate that that may be the case in respect to one aspect anyway of the consultation, will that not inevitably or ultimately mean that you'll have to redo the consultation?
Sorry, what part did you?
You indicated that in respect of the shortened, the version that was shared with young people.
That was an allegation included within
Yes.
the pre-action complaint letter
Yes,
rather
but
than...
you seem to concede the point by saying that might have been a mistake, not to include the EQIA, I think it was, in respect
I
of...
think that's just what we said, that in hindsight, because those were comments received from the consultation process and then subsequently reiterated within the pre-action letter, then in hindsight we might have done it differently. I think.
Yeah, but I don't think we're suggesting that
question of
it would be a breach of our
No.
equality scheme
No.
by that omission.
You haven't had legal advice to that effect, have you?
Well, as you say, any legal advice that we have is privileged.
It was rhetorical. Then my next question is, if we assume that there's no anti-discrimination legislation come before the Assembly in this mandate, that's a breach of the programme for government.
Well, I mean, I can't really assume anything at this stage.
In the event that there's no legislation before the Assembly by the middle of March, or passed by the middle of March, which is probably a challenging time frame given that it's going to be a few weeks before you give policy proposals to your ministers. That's a breach of the programme for government if there's nothing done in this mandate.
Well, yes, that's right, yes.
On the far side of this mandate, the functions that we're talking about today, children's and older persons, will be transferred to other departments. See of the appointment of the Children's Commissioner and the Older Persons Commissioner, which will, for some reason or other, be retained by OFMDFM. We learned that last week. How many staff persons will be transferred in relation to this, in relation to Children's Commission and children's issues and functions transferring out of FMDFM to communities? Is it going to communities? Oh, how many staff will follow as a consequence?
First of all, HGFS won't transfer, it's remaining with...
That's remaining, is it?
And the team that I have will remain in place. In terms of the children's services, the Children and Young People's Unit is transferring in its entirety, and I think that's 8 people at this stage.
To the Department of Education.
To the Department of Education, yeah, and Department of Communities, in terms of the sponsorship role of the Children's Commissioner, then is 1 member of staff.
If ministers get policy proposals by before the end of this mandate, essentially that's going to go into a new PFG in the event that it can't be passed by the Assembly in this mandate, isn't that right? Are there conversations going on in respect of the PFG as to what might go into the PFG in respect to this matter?
Well, I understand certainly there are conversations going on in relation to PFG. I mean, I think it's... I don't know, actually, if the HGFS is one of those areas that has been considered at this stage, but I can come back on that if necessary.
Like, if the PFG falls at the end of this mandate, this will have to be the next PFG. And hopefully it'll extend to those under 16 as opposed to those other age categories. Thank you. Oh, sorry, and just to acknowledge, this has been a more forthright presentation and some others have been in relation to matters that touch upon the life of FMDFM, and thank you for that.
Yes, that's a good point to finish on. Thank you all, and obviously we would very much appreciate live updates, or as close to as possible, on the situation with regard to the pre-action letters.
Yes.
Possible.
Yeah, okay. Thank you.
Sorry, Margaret Rose, sorry, just before you... Sorry, we're looking at the transfer functions. And it says that age and older people is going to the Department of the Communities.
It's older people's policy and the age... Sorry, the age...
The regulations that relate to age discrimination in the field of employment.
Yeah, not on HGFS.
You're retaining the former
Yes.
and transferring the latter.
No.
No, transferring
the former and retaining the latter.
Yes, that's
Why?
right. Well, the age employment regulation part, it's just a very small part of that is the responsibility of OFMDFM at the moment. In terms of age GFS, there is no actual legislation in place, obviously, at the moment. So the policy development part of that is remaining within the new executive office just for the time being. Once the legislation is in place, then I think consideration will be given to what department it should fit with.
Right.
Sorry, and that will be borne out in the legislation itself then?
Well, most likely, yes. That, yeah, where responsibility would have been normally for OFMDFM, it would be whatever the new department would be for it.
Okay, and Margaret Rose is staying with us, members, as we switch our focus to the EU Equal Treatment Directive, also known as the Horizontal Directive. Again, a number of papers. Clark's brief, page 265. Correspondence from our EU Affairs Manager, Shona, page 267. The consolidated text of the Equal Treatment Directive starts at page 274. The EU Equal Treatment Directive, the explanatory memorandum, begins at page 307, and Assembly Library Research paper on the directive, page 312. And on that basis, I think the department decided that there was nothing further to add by way of briefing papers. We are going to hear from the Quality Commission on this, and normally we might do that and then hear from officials, but we're starting with officials on this occasion. So Margaret Rose on this occasion is joined by David McGowan. And again, Margaret Rose, I'd ask for your opening comments, please.
Okay, well, just to say, Chair, that I mean, obviously this directive was first published by the European Commission way back in July 2008, so it's been ongoing for a number of years. In 2009, there was a UK-wide consultation on the Commission's proposal for a directive, and that was carried out by the Government Equalities Office in the UK, and I think the committee received a copy of the consultation document and the responses to the consultation, or a summary of the responses to consultation at that time. And again, the Assembly Research and Information Service produced a briefing paper on the directive back in August 2011, and I understand that that briefing paper was considered by the committee in October of that year. The text of the directive has undergone a number of modifications since 2008 as a result of the negotiations between Member States. And so in September 2015, the Commission produced a consolidated text of the directive. So the current draft reflects the current state of play in negotiations, and it was produced more for convenience and without prejudice to Member States' negotiating positions. The draft directive builds on the approach and concepts of the existing anti-discrimination directives. For example, it would prohibit direct and indirect discrimination and prohibit harassment related to the 4 protected characteristics, and provide protection from victimisation. So the deposit of the consolidated version of the directive at Westminster activated Westminster's parliamentary scrutiny process. The process by which Westminster examines all proposals for EU legislation is obviously the parliamentary scrutiny process, and this is done by way of an explanatory memorandum. The explanatory memorandum was deposited at Westminster on the 20th of October. It summarised the draft directive, its legal policy and financial implications. I think maybe the committee got a copy of the explanatory memorandum. It also includes a section on the interests of the devolved administrations, and you'll see that it highlights where the executive has conducted the public consultation on age, on proposals to extend age discrimination to the provision of goods and services. As members are aware, we don't currently have any protection from age discrimination by those providing goods and services. Protection from age discrimination within the workplace has been in place since 2006 in compliance with the age strand of the Employment Framework Directive of 2000. The explanatory memorandum that the UK government has produced indicates that the UK government has some concern still about the impact of elements of the text of the directive These concerns include the proposal to include education within the scope of the directive and also to protect under 18s from age discrimination. Despite these concerns, the UK Government remains positively engaged with negotiations on the directive. As I mentioned earlier, the proposals have been under examination since 2008, and while negotiations have proceeded slowly, some progress has been made under different presidencies. At a meeting of the EU Ministers in December 2014, it was concluded that there was still sufficient support for continuing the negotiations, but it is clear, I think, that there are still a number of significant issues that need to be resolved. Some of these outstanding issues include concerns about the overall scope of the directive, concerns that the proposal infringes on national competence for certain issues, concerns about disability provisions, including accessibility and reasonable accommodation for persons with disabilities, concerns regarding implementation calendar for the directive, the need to ensure legal certainty, and the overall financial and practical impact of the proposed directives. Obviously, the proposal can only become law if all 28 member states agree to it unanimously. So I think for the time being, while all member states are relatively positive about the directive, I think they still maintain general scrutiny reservations on the proposals. And that.
Okay, thank you very much. I think, first of all, I would like to know about your assessment of the potential implications for policies coming out of OFMDFM, and we did ask in the previous session about any implications for age discrimination GFS legislation. You're still saying you don't think, even if you were to get through that piece of legislation in a timely manner, that anything coming out of Europe would force a rethink or a rewrite?
Well, certainly we don't have any indications at the moment that this is likely to be agreed in the near future. David, do you want to say anything about the time frame? And certainly in terms of the impact on our current policies or legislation, the age GFS one is the one that there is the big gap in. We do have, I think, a wide range of legislation that covers other areas within the directive. Is that fair to say, David?
Yeah, I think sort of clearly, obviously, the main impact would be in the area of age discrimination. If the directive was there now, it would require us to have legislation to protect age discrimination in the field of goods and services. At the moment, it's not there. So, at the moment, we are legislating or trying to legislate in that field. There's nothing to say that if we legislate in advance of any agreement on the directive in the area of age, that the age directive would sort of require us to set things aside. Obviously, a lot of that will depend on how we agree on the proposal in relation to age discrimination. If it's maintained at the current proposal, there may be an implication.
Which would be?
Well, the directive may require discrimination to apply to all ages.
Under 16s?
It may, if that's the way it is agreed.
So we could go ahead with the current proposal, which was for over 16s, put it into law, and then the Equal Treatment Directive comes out of Europe, and it says you must have anti-discriminatory legislation for under 16s.
That would be a potential scenario, yes.
Yeah.
And what is the latest timeline for this EU Equal Treatment Directive?
There isn't a timeline. It has been with the Council since 2008.
But you have asked. Have you asked when it is likely to become law?
Well, no, we haven't asked.
But you're spending a lot of taxpayers' money advancing a piece of legislation which, by your own admission, may fall if this becomes law. And you haven't even asked. Well, is this likely to become law within months of us passing?
Well, certainly there's no indication that the proposal will.
But you haven't asked.
We haven't.
Well, there is a section within the explanatory memorandum that was laid before Westminster, which does give an indication of the timetable in relation to the directive.
There is.
So therefore, in terms of the UK government's view in relation to the timetable it's set out in the explanatory memorandum.
Well, do you want to remind us what it says? Because it doesn't give me much of a clue.
Well,
Paragraph 36 of the explanatory memorandum talks about negotiations on the directive have lasted 7 years.
Yeah.
Proposals
What about paragraph 37?
It was concluded that there was sufficient support to continue negotiations and to work towards unanimous agreement. Yes, I mean...
That could be next week.
Well, yes, it could be, and I guess it depends as well on who the priorities of the presidency at any given time.
There is a Northern Ireland Executive Office in Brussels.
Pardon?
We do have an office in Brussels, an executive office in Brussels, and you haven't asked.
Well,
Any idea when you think the EU Equal Treatment Directive might become law?
The UK, as you know, will be undertaking the negotiations on behalf of all of the jurisdictions within the UK. We can certainly, and I can come back to the committee on that with a timetable if they can provide me with a timetable. But certainly we will ask the Government Equalities Office.
but I think at this stage it's very difficult to speculate whether this, would become law in the near future. It's my understanding that there's no immediate prospect of this becoming law.
Okay, I'm going to leave it here, but it's very difficult to speculate, David, if you don't ask.
Well, as I say, we have spoken with the lead department that's taking this forward on behalf of the UK government.
Can I ask then, outside of age discrimination, are there any other strategies or policies that could be affected?
Not large-scale policies. Certainly, there may be impact on the existing legislation that we have. One of the areas that sort of is highlighted is provisions in relation to harassment. That the directive will require harassment, and there's a couple of equality grounds that in the area of goods and services that don't actually currently have that. So that would perhaps require amendment there. It is sort of not large-scale policies, but there are nuances within existing law which may require amendment, and harassment is one of the areas which would require change.
Any areas of policy development?
None that I'm aware of at this stage.
So, as I say, to a large degree, the areas that the directive is proposing to legislate in, we already have a fair amount of existing legislation on, in terms of religion and belief.
No implications for the sexual orientation strategy?
No, not for the strategy in itself. We do have the sex discrimination order and the Equality Act, the sexual orientation regulations, where it is already unlawful to discriminate on grounds of sexual orientation and the provision of goods, facilities and services. So that is already in place there. Sexual orientation strategy is more about giving effect to the law as it currently stands. Okay. Certainly if there was anything in the EU directive that may impact on that, we would want to be aware of that in developing the final sexual orientation strategy. But the fact that we already have regulations there that protect in terms of goods, facilities and services would suggest that.
Yeah, well, so just to be clear, one of the grounds, I mentioned harassment there, one of the grounds that would be affected is the area of sexual orientation.
In terms of harassment?
In terms of harassment, but I say it's not got implications for the strategy as such. Yes.
The explanatory memorandum coming out of London, I think, makes clear that they believe that competence in relation to education is very, very limited, and actually that these proposals go too far. Would you share that concern?
Well, yes, I think we would, given the issues that we're facing in terms of identifying the many strands of issues around education just locally here. I think it would be it would be more difficult then for the EU to potentially legislate on behalf, of our, certainly of the UK and of our jurisdiction, just given the complexities around education.
Any other concerns with regard to the potential impact as proposed on how we do business here?
No, I can't. David, have you any other?
No.
I mean, we have looked at the various equality provisions that we have. And we have a fair range, or a wide range of equality provision. Age is the one that is where the big gap is. That and harassment then are the two main issues I think that we would look at.
Okay. Members content? Okay, David, Margaret Rose, thank you very much.
Thank you very much.
And members, we will continue on the theme of the European Union's Equal Treatment Directive for our final briefing of the day, which will come from the Equality Commission. A briefing paper from the Commission is in your main pack and begins at page 320. And joining us, we have Roisin Mallon, who's the Senior Policy Officer with the Equality Commission, and the Chief Executive, Dr. Evelyn Collins, CBE. Evelyn, would you mind, given what you've heard in the two briefings to date, if we very quickly asked what, if anything, you can tell us about these pre-action letters with regard to the consultation and the proposed age discrimination legislation which have come to you for adjudication?
We've received one.
From
Nikki. We've been copied into a pre-complaint letter sent to OFMDFM from the Children's Law Centre, but we were copied into the pre-complaint letter sent by Nikki to OFMDFM in the autumn time, and we've received just before Christmas a request from Nikki to the Commission to exercise its discretion to undertake an investigation under paragraph 11 of Schedule 9 of the Northern Ireland Act to investigate allegations about complaints of breaches of OFMDFM's equality scheme in respect of a number of matters relating to the policy consultation and equality impact assessment that you've heard discussed earlier. So that came in just before Christmas. We have been looking at it. Decisions on investigations, decisions whether to investigate or not, are taken by a committee of commissioners in the context of Para 10, which is for those who are directly affected by the alleged breaches. Paragraph 11 complaints, which are on the Commission's initiative, are decided by the full Commission, and we're working to bring forward a paper for that for the next relevant committee meeting early in February.
I appreciate you giving us the context under which you look at it, and I'm not going to press you on detail because I don't think that would be appropriate, but I think it's not inappropriate to ask if, in your experience, you could tell us how usual stroke unusual it is for an arm's length body such as Nikki to issue this sort of letter against their sponsor department.
I can't think of another occasion when it's happened, although we're aware, of course, that there are many occasions when arm's length bodies have concerns about what their sponsor body is doing. But if there are any instances, we'll certainly come back and inform you on it. Off the top of my head, I can't think of another one.
Having served with the Equality Commission for how long?
15 years.
Thank you very much. Okay.
Could I also add that in relation to the prior discussion, Chair, the Equality Commission, along with Nikki and Copney, as you know, had been very keen to press OFMDFM to ensure that the age discrimination legislation does indeed cover all ages, and I hope that has been clear to you in the various briefings we've done for you over the years. So we were very interested to hear, as best we could, from behind the report on the consultation. That was helpful.
Well, again, I thank you for giving us the broad context, and we do not wish to sort of prejudice the actual process with regard to these particular letters. So we return, members, to the Equal Treatment Directive. Would you like to make some opening comments, not
Yes.
least having listened to the officials?
No, thank you indeed. And as you know, Roisin Mallon, Senior Policy Officer, with me. Also, thank you very much for the invitation to be here this afternoon to give you the Commission's views on the draft directive. I hope you found the briefing note we forwarded helpful. I realised with horror this morning that the word age is omitted from a couple of sentences where it should be included, and I would certainly welcome the opportunity to resubmit for the records a corrected version on that. But you know absolutely from the footnotes and the text that age, religion, belief, disability and sexual orientation would be covered. The Commission has been very supportive of the introduction of this directive. We responded very positively to the 2009 UK-wide consultation on this. We do believe that outlawing discrimination in the provision of goods and services, access to social protection, including social security, healthcare and education on the grounds mentioned in the draft directive is important for a number of reasons set out in the briefing paper. First, it would address a gap in EU-level protection. There's protection in these areas on grounds of gender and race to date, but not on the other areas, so this would level up protections for people across the EU. It would certainly strengthen Northern Ireland equality law. You've heard the most obvious gap is in relation to age and goods and services, but there are other areas too in which legislation could be strengthened here, such as the provisions in relation to harassment. We believe strongly having an EU-wide directive would help challenge discrimination in these grounds across the EU, and there are not only legal benefits to that, but also social and economic benefits to have a level playing field for all people across the EU, and has benefits of economic and social cohesion. And finally, we would be very clear that it would ensure greater harmonisation both across member states, where some countries of course already have provisions that go further than what is in the draft directive, but also importantly, and you've identified this already, within the UK, where there is significant gap now between the Northern Ireland Equality Law Framework and that in Great Britain. You'll see from the explanatory memorandum that the GB that the UK government was relying on the fact that the Equality Act 2010 is in place and provides, I think the figure is 90% of what is in the draft directive is already provided in GB. Of course, that's not the case in Northern Ireland, where protection against age discrimination in goods and services is not yet in place. So it will ensure greater harmonisation both in terms of across the member states, but also in terms of within the UK. So from the Commission's perspective, the European Union has been a leading influence in the development of equality law across the European Union, since the first equality directives on gender in the 1970s, and we would certainly welcome the committee encouraging the UK government to take action aimed at securing agreement. Unanimity is required, but securing agreement on the draft and to adopt a strong negotiating position in relation to this directive. Thank you.
Now, as you know, it's been around since about 2008, 2009. Have you been following the journey, and how would you characterise it?
Difficult. There are certainly one or two member states who feel very strongly about the area of whether the European Commission, the European Union, has competence in this area. So issues of subsidiarity are important as a blanket concern, particularly for Germany. There are other countries, including the UK, which have retained parliamentary scrutinies on the legislation, who are concerned about some aspects. And certainly, as you heard earlier in the explanatory memorandum, for the UK's government's perspective, that is in respect of the coverage of those under 18, in respect of education and in respect of social protection. So a number of countries have specific points of concern. When the Juncker Commission came into place in the middle of 2014, it reviewed all of the pieces of legislation that had been outstanding. It felt there was merit in progressing this, and certainly the number of presidencies that have gone before have sought to move discussions on, most recently under the Luxembourg presidency, and certainly you can see Social Questions Working Group considering it in November, and still seeking to try to reach some unanimity on this. So it's been an area where the Parliament has been very interested, where civic society at a European level have been, very strongly trying to encourage this directive in order to complete the EU legal framework, but there's obviously intense discussions amongst members of the Council from different perspectives have been not leading to unanimity as yet.
Okay. And this issue of subsidiarity and the competence with regard to education, just to nail a view on that.
Well, certainly the race directive, and I'll let Roisin come in for that. Certainly the race directive, which was adopted in 2000, covers education, and the most recent discussion has provided some clarity about what would be covered and what wouldn't be covered by the provisions, but perhaps Roisin might say a word on that.
Well, currently in terms of domestic legislation and education, we know there are already provisions, for example, on disability. You have SENDO, you have race provisions covering education, and the sexual orientation legislation covering education. So we already, under domestic law, have protection in those areas, but where the gaps are at the moment relate to age and fair employment, which doesn't cover education in schools. So we do have some gaps already in terms of the coverage of domestic legislation. The UK government has expressed some concerns in terms of the EU competence, and they've said that the EU competence in relation to education is extremely limited, and they have concerns that the current text goes beyond the limit of the EU competence. Though interestingly, when you look at the text of the current draft, it makes clear that some areas of education are carved out. So they're saying it's not going to impact on the curriculum, it's not going to impact on age limits regarding eligibility for schools. So clearly it's not everything in education. So they, as I say, the UK government think it goes too far, but when you look at the draft is clearly not everything in education. There's bits carved out.
Yeah. Thank you. Alex Maskey.
Thank you, Chair. Thank you for the presentation. Submission. In the submission, you referred to obviously the Commission supported the draft directive back as far as 2008, I think maybe. But you also said that it could also be expanded, or key areas of actions could be expanded. Could you outline what those might be?
Yes. Just generally, as I say, we did support a lot that was included in the post directive at that time when it was consulted on 2008. Obviously things have changed since we responded in 2009. It does cover areas like education, housing, public functions, social protection, all of which we agreed with. There are some concerns. For example, they were proposing to cover association due to discrimination, but we were saying should also cover discrimination due to perception. So if someone's perceived to be a certain age or a certain religion, that should be covered, so that explicitly wasn't covered. The UK government had proposed that it didn't cover premises. At that stage it wasn't proposed. It is now in the draft, so as I say, things have changed since we raised concerns. We also recommended it covered all ages, and the UK government had indicated that they didn't want it to cover all ages, only adults. So again, we had concerns about that proposal. And again, the UK government had said they didn't want the directive to cover harassment on the grounds of religion and belief and sexual orientation outside the workplace, and we said it did. So those were our main concerns about the draft at that time.
Thank you.
Members, any other issues, questions, comments? Okay. Roisin, Evelyn, thank you very much indeed. It's useful, thank you. So members, just to finish off on this, the European Affairs Manager, Shona, has advised the House of Commons Scrutiny Committee on European Affairs has retained this proposal under scrutiny, and the House of Lords EU Committee sifted the proposals to a subcommittee for further scrutiny. So it's obviously something that Westminster isn't content about. What I was wondering is whether, in the spirit of that UK-EU body, we should write to those two bodies and just say we've been looking at this and here are the main areas of concern that we have identified and which have been brought to our attention. You happy enough? Thank you very much. And the clerk will bring a draft back next Wednesday for agreement. Okay, thank you. And finally, in terms of the agenda, We've already received a briefing from Assembly Research and Information on items relevant to OFMDFM's analysis of the EU Commission's work programme for 2016. We had a briefing on that, then we agreed staff would prepare a draft submission for inclusion in the committee report on Assembly EU priorities for 2016. That is on page 325 of your PACS members. And it also includes an update on the 2015 priorities, and I'm now going to ask Cathy to talk us through.
Thanks, Chair. I'm not going to go into detail. As the Chair said, the researcher ran through this a couple of weeks ago with the committee, but the priorities for 2016 just reflect the four main priorities that were included in the research paper at that time. So there's the New Skills Agenda for Europe, New Start for Working Parents, Labour Mobility Package and Better Migration Management. And of those four, three will actually remain, from what I can gather, with the Executive Office. One will move its relevance, the New Start for Working Parents really has relevance to the Gender Equality Strategy, which will move to communities. But this committee can recommend, obviously, that committee, the new committee would take that forward. The others have relevance to the Racial Equality Strategy and the Racial Integration Strategy that the Executive Office will retain responsibility for. A fifth priority actually is the committee's role in respect of subsidiarity monitoring. And members may wish to note, it's at page 329 of the pack in the draft, that in the House of Lords, in their correspondence to President Juncker, have actually raised noted the UK government has raised subsidiarity concerns in respect of actions in the work programme, including the New Skills Agenda, the New Start for Working Parents and Caregivers, and the proposed Pillar of Social Rights. And the House of Lords Committee has actually sought an assurance that the principle of subsidiarity will be respected in those cases. So in respect of that issue, this committee then will continue with its subsidiarity monitoring and reflect any comments back to, or any views back to the European committees as necessary to feed into deliberations at Westminster. Just at the bottom of page 329, other EU activity planned for 2016. Obviously, the difficulty is that we're coming to an end of a mandate. Before the end of this mandate, this committee would hope to have the final report on the EU executive priorities for 14-15. Confirmation of the priorities for 15-16, and then the committee had also requested a briefing from the EU Affairs Manager. So the final paragraph there just says that this committee recommends the proposed committee for the Executive Office, subject to the Department's bill receiving assent, takes forward the priorities identified above. I just would propose to amend that to say the Executive Office and the Department for Communities, given that they will have the Gender Equality Strategy, if members are content with such an amendment. Then the draft also outlines the activity that was undertaken in 2015. Just to skip to page 331, in respect of two priorities, actually, the Labour Mobility Package and the European Agenda Migration. The committee has undertaken actually quite a lot of work in monitoring PFG in terms of TBUC and its own TBUC inquiry. And also towards the end of last year received briefings relevant to the refugee and asylum seeker crisis. So it's done quite a bit of scrutiny in that particular area. The third priority was accession to the ECHR, but there was no progress on that, so there was really nothing that the committee could do. And there were no subsidiarity issues brought to the committee either in 2015. Page 333 just lists some other, apart from the priorities, other issues that were looked at in 2015. So there were departmental briefings on follow-up to the committee's report in the Barroso Task Force. The committee obviously met with Lord Boswell in respect of the House of Lords European Committee's inquiry, divisions of EU reform. The Assembly hosted EC UK towards the end of November. And obviously towards the end of last year, again, the committee has been trying to ascertain how the executive has been feeding into the EU reform agenda. and how the Westminster government are taking that forward, and that's still an ongoing issue. And that's the draft.
Excellent. Comprehensive. Thank you very much. Yes. Members, questions, comments? All done? Yep. Going once? Okay. Cathy, thank you very much indeed. So, favourite question of the day, members? Any other business? If not, we adjourn to Wednesday the 27th of January, 2 p.m. here in room 30. Thank you very much.
Room 30.